our today's topic is Writ of Mandamus. Every day we get a lot of email, a lot of call about Writ of Mandamus because many people, they're curious to know about Writ of Mandamus. It's a fairly new topic in immigration law, of course, because basically Writ of Mandamus is not a law related to immigration. Writ of Mandamus is the administrative law. The purpose of Writ of Mandamus is to expedited government services. You know, America has multiple layers of government. On the top, there's a federal government, and then there's a state government, and then there's a municipal government. And not only government, if there's any semi-government, non-government organization, and if they do anything, when they provide any service, and the beneficiary of the service, provided service, if they do not get any benefit within the reasonable time. Here, the tricky part is the reasonable time. If they do not get within a reasonable time, then they can file a writ of mandamus in a federal court to compel the organization, either it's a federal, state, or municipal government, or any organization, to compel the organization to do their job on time. However, we use this administrative procedure law for the purpose of immigration benefits. That's why, like, a lot of people, they had no idea about Writ of Mandamus, and now it's getting popular day by day. That's why today we are going to talk about Writ of Mandamus. Next slide, please. So, what is Writ of Mandamus? As I said, it is a lawsuit in a federal court to compel a USCIS officer or another court to do their job within a reasonable time. Here I said USCIS officer because our show is all about immigration law, but it doesn't have to be USCIS officer. It can be a USCIS officer, an embassy officer, or anybody who is involved with in any government agency. So it's a lawsuit in a federal court to compel a U.S. government official or another court to do their job within a reasonable time. Now, what is a reasonable time? That's very subjective. It depends on many factors. I'm going to talk about that in a minute. But in general, the law says reasonable time. All right, next slide, please. Okay, so when you can file Writ of Mandamus? Anytime when there is an unreasonable delay, and that can be in any steps or any stages of immigration. Here I mentioned before the fingerprint, before the interview, before the result, before the court hearing, and it can be any office. Like, let's say you filed for an immigration benefit in a U.S. embassy in a foreign country. And let's say the embassy is not doing their job on time, then you can file a Writ of Mandamus against that U.S. embassy in the foreign country. However, I must tell you that there is a doctrine. It's called Doctrine of Consular Non-Reviewability, meaning most of the, or at least a handful of embassy activities, like a consular activities, is under the Consular Non-Reviewability Act. We cannot file mandamus for those actions. I'm not going that detail into consular non-reviewability because that's not the scope of our discussion today. We will probably talk about consular non-reviewability another day. However, just keep in mind that not all kind of delay is addressable by Writ of Mandamus. Let's say that in that way. Let me give you another example. Let's say you are a US citizen, you applied for your siblings, and there is a 14-15 years delay because of the visa bulletin. That delay is not addressable under Writ of Mandamus because that delay is a procedural delay, and it is not, it's not like administrative, or it's not like, any negligence related to delay. That's why you cannot file Writ of Mandamus to address that delay. However, all other kind of delays you can address through Writ of Mandamus. Okay, next slide, please. So, what is an unreasonable delay? That's a $1 million question, because anytime I talk to any client about Writ of Mandamus, they ask, so what is an unreasonable delay? So nobody knows what is an unreasonable delay. That's like the short answer. Nobody knows what is an unreasonable delay. However, for the purpose of our practice in our firm, so every lawyer, every attorney will define unreasonable delay in their own way. Every judge will decide unreasonable delay in his or her own way. USCIS officers will define in their own way. So everybody who is qualified to interpret law, they will define unreasonable delay in their own way. However, for our purposes, Can I go to the next slide? Yes. Okay. No, this is not the one. Okay. So, but please keep this slide. Okay. So for the purpose of our firm, we defined unreasonable delay in a certain way. So, for example, let's say you applied for a student visa in U.S. Embassy, Ghana. I'm just saying, just giving example. And let's say the embassy kept you in administrative processing for more than 6 months. Then, you know, for a student visa, F1 visa, in my opinion, it's an unreasonable delay. And you can file writ of mandamus to expedite your case. On the other hand, if it's a family-based application, and let's say you are documentarily qualified, everything is good, the embassy is ready to schedule your interview, and they are not doing it. And let's say you applied for, you know, for siblings in the country of Nigeria. If you have been waiting for more than 1 year after you are documentarily qualified and an embassy is ready to schedule an interview, then you can file writ of mandamus. So for family-based application, 1 year, I would say is enough. It's an unreasonable delay. Let's say asylum. You applied for asylum within America, and let's say you are not getting, you know, your fingerprint done, getting your interview or anything. You're not getting it. I suggest to apply. Wait at least 1 year. Better if you wait 2 years and then you apply for writ of mandamus. Then this is better. On the other hand, for H1B, 2 months waiting, I would say a unreasonable delay. For L1, O1, I would say 4 months. So it depends. It depends on the case, depends on the background, depends on the country. So yeah, that's the thing. Like, you know, nobody knows what is the unreasonable delay. It depends on many factors. But anytime, you know, you see that, yeah, I've been waiting for a long time, I think then you can consider for writ of mandamus. All right, for this slide, so before filing a mandamus, I would like you to take certain steps before you file writ of mandamus. And here are the things what you should do before you file writ of mandamus. First, you must exhaust all available options, because, you know, mandamus is a lawsuit. You're going to a federal court. You're filing a case against U.S. government. So I would like you to, you know, try all available options, exhaust all available options. Only then you file writ of mandamus. Also, you request the office to expedite your case. So let's say your case is pending in a U.S. embassy in Dubai. I'm just saying. So you request the U.S. embassy in Dubai to expedite your case. Let's say your application is pending in NVC, National Visa Center. You request them to expedite your case. After that, you can also contact Immigration Ombudsman Office. Let me spell out that for you. OMBUDSMAN, Ombudsman Office. They can also inquire about your case, and sometimes it helps, sometimes it doesn't, but at least it's worth trying, and it's free. You know, you do not need to pay any money for Ombudsman Office inquiry. So try that before you file writ of mandamus. Also, federal senators, congressmen, they have authority to inquire about any case to USCIS. Sometimes it helps, sometimes it doesn't, but it's free and it's worth trying. After trying all these options and exhausting all the available options, then you file writ of mandamus, because, you know, writ of mandamus is expensive. Court fee is $405. On the top of that, most of the attorneys will charge like a $5,000 to $10,000 just for this lawsuit. We charge way less than most of the attorneys, but we charge like a $3,000. Plus, we need to ship a lot of files to different defendants. In general, there are like 10 to 12 defendants. So sending those files to those defendants is also expensive, right? Almost $200, $300 just for the FedEx fee. So since it's an expensive process, I would like you to try all the, you know, available options. And if you do not get your expected result, then file writ of mandamus. Next slide, please. All right. So what are the steps? So first, you know, we file lawsuit to the court. So, you know, the court is also very subject to define, because in America, there's almost 200 federal courts. You know, depends on, you know, that's a whole new calculation. You know, it's called venue shopping. I know it's a legal term, so many of you may not understand, which is totally okay. So which court we are going to file lawsuit, that also depends on many factors. Again, I'm not going that detail here because it would be, you know, it will be very complex for you. So first thing is we file a lawsuit to the court. Once you submit it to the court, we receive summons from the court, like, you know, sealed summons in the from the court. Then we print the summons, and we, including all the document and the actual petition, we ship it. We send those to defendants. The common defendants are for immigration purposes. Number one, USCIS director. If it involves embassies, Secretary of State, Secretary of Justice, and also, let's say your case is pending in U.S. Embassy in, let's say, Ghana. I'm just giving an example. So we will definitely make, U.S. Ambassador to Ghana, Consular General, and all the appropriate officers. They all are defendants to this lawsuit. So in general, there are like 10 to 12 defendants, and we send summons to all defendants. Once defendants receive summons and other documents from us, they communicate with ASA, Assistant U.S. Attorney. So there are many, Assistant U.S. Attorneys in their own jurisdiction. So defendants contact them, and ASAs, they contact us. So we have a regular communication with ASA. At the same time, we have a regular communication with the court. And, in general, most of the writ of mandamus cases, at the end of the day, it doesn't go for hearing. However, it may go for hearing, but it doesn't go to hearing. Most of the writ of mandamus cases are resolved before going to the actual hearing. That's why it's very beneficial for the client. So at the end of the process, of course, you get your result. Next slide, please. All right, few things to know for writ of mandamus. So, purpose of mandamus is not to approve your case. Many times clients send us email and call me and say, hey, is it guaranteed that I'm going to get the visa? The answer is no. Nobody can give you guarantee about anything, especially in legal world. There's nothing 100% guaranteed. If anybody tells you it is 100%, he is lying or he has no idea about law. So in legal world, it's not binary. Many of you are probably know about the computer binary system 0 and 1. Law is not binary. Law has a lot of gray area, and at the end of the day, everything depends on many factors. So the purpose of mandamus lawsuit is not approving your case. The purpose is to expedite your case. Now, in most cases, when we expedite any case, cases get approved, visa get approved. Because if USCIS or the officer had any reason to reject your case, deny your case, they would do that, even before going to that time. So the reason the case is still pending because they cannot make their mind or they're waiting for some document or something. That's why when we file writ of mandamus, in most cases, cases get approved, but doesn't mean that the purpose of mandamus is to get approved. All it means for the purpose of mandamus is to get the case expedited. That's it. There is no fixed course of action. There's another thing. So many times our clients say, hey, my friend filed a writ of mandamus and he got this after that. So please remember that there is no fixed course of action. When it comes to court, every court is different. Every judge is different. Even sometimes same judge, he or she said something, let's say 2 months ago, and today he or she is saying a totally different thing. It happens all the time. So when we attorneys, we deal with a case, we know that every case is unique. Every case's course of action is different, and we act based on the action taken by the ASA or by the court. We cannot just follow a fixed course of action. There's nothing like fixed. It depends on the situation, and we react based on the situation. So please remember that there is no fixed course of action. Also, you will not understand all activity. This is another thing, it's a court procedure. Court procedure is a complex matter. Even when I studied law in law school, just the civil procedure, it's a 3-credit course, and civil procedure is one of the toughest course in law school, US law school. So court procedure is complex. Again, it depends on different factors. It depends on the judges, depends on the court, depends on the level of the court. So please do not try to understand everything, because it will be your waste of time, and you'll not, at the end of the day, it will make you feel even bad. So I tell my clients, please do not try to understand everything. When you hire an attorney, trust your attorney. Your attorney is well equipped to take care of your matter, and they have license, they have education, they have everything. So trust your attorney and let him or her take care of your matter. Do not try to understand every single petition, every single steps. That will make you feel bad. I can tell you that from my experience.